The United States is home to hundreds of beautiful national parks. Visitors make use of the park's public facilities, lodging, restaurants, and souvenir shops. But do these providers have concession contracts with the government? Whether a court would hear this issue was a fatal hurdle for the claimants in National Park Hospitality Association versus Department of Interior. Congress gave the National Park Service authority to issue permits, leases, and privileges to accommodate people visiting the national parks. In 1998, Congress passed the National Parks Omnibus Management Act to create a new system to manage concessions at the national parks. The act gave the Secretary of the Department of the Interior the authority to implement the act, which she delegated to the National Park Service. The Park Service explained in a regulation that, under its interpretation of the act, only contracts for government procurement of goods or services, not licenses the government granted concessioners to sell goods and services to the general public, met the definition of government concession contracts. Under this view, the nearly 600 concessioners that merely had licenses to operate such businesses as restaurants, lodges, and gift shops didn't have a concession contract with the government and wouldn't be subject to the Contract Disputes Act. The National Park Hospitality Association represented these concessioners and challenged the validity of the Park Service's regulation defining concession contracts. The Hospitality Association brought suit against the Department of the Interior in the District Court for the District of Columbia. The District Court deferred to the National Park Service's interpretation. The Hospitality Association appealed to the Court of Appeals for the District of Columbia Circuit, which agreed with the Park Service's interpretation and affirmed the District Court. The United States Supreme Court granted cert.